If you're facing federal criminal charges in Texas, understanding how federal sentencing guidelines work can literally mean the difference between years in prison or a significantly reduced sentence. I'm Michael Lowe, a board-certified criminal defense attorney in Dallas, and today I'm going to explain how federal sentencing actually works and what you need to know to protect yourself. The federal sentencing guidelines were created by the U.S. Sentencing Commission in 1987 to bring consistency to federal sentencing. These guidelines used to be mandatory, but in 2005, the Supreme Court changed everything with United States versus Booker, ruling that mandatory guidelines violated the Sixth Amendment. Now the guidelines are advisory. Don't misunderstand advisory, though. Judges still have to calculate the guideline range, consider it carefully, and most federal sentences still fall within or very close to the calculated range. They're hugely influential in determining your sentence. The guidelines work on a grid system with two main components: your offense level and your criminal history category. Your offense level ranges from 1 to 43. It starts with a base level for your crime, then gets adjusted up or down. In a drug case, the weight of the drugs drives the offense level. If you used a weapon, that adds levels. If you were a leader in the criminal activity, that adds more. There are also reductions. The biggest is acceptance of responsibility. If you plead guilty and genuinely accept responsibility, you typically get a 3-level reduction. That alone can shave years off your sentence. The second component is your criminal history category, which ranges from 1 to 6 based on prior convictions. Category 1 means little or no criminal history. Category 6 means an extensive record. The difference between the categories can double your prison time, even with the same offense level. These two numbers intersect on a sentencing table to give you a range in months. That's your guideline range, and it's what the judge uses as a starting point. Besides acceptance of responsibility, there's the safety valve. If you meet the criteria, minimal criminal history, no violence, no weapon, no role adjustment, and you provide truthful information about your own conduct to prosecutors, the safety valve can eliminate mandatory minimum sentences and reduce your guideline calculation by 2 levels. It has helped thousands of first-time offenders avoid the harsh mandatory minimums Congress attached to drug crimes. There's the minor or minimal participant reduction. If you played only a small role, you can get a 2 to 4 level reduction. There's also the 0-point offender reduction under Section 4C1.1. If you have no criminal history points and your offense doesn't involve violence, firearms, or other disqualifying factors, you get a 2-level reduction. If that drops you into Zone A or B of the sentencing table, the guidelines themselves say a non-prison sentence is generally the appropriate sentence. On the flip side, enhancements can devastate your sentence. A leadership role can add 2 to 4 levels. Obstruction of justice, lying to investigators, or destroying evidence adds 2 levels. Sophisticated means adds 2 levels. In fraud cases, the loss amount can be a killer. A fraud case with a loss amount of $1.5 million to $3.5 million in losses can add up to 18 levels to your base offense level. That can turn a probationary sentence into years in federal prison. Some federal crimes come with mandatory minimum sentences written directly into the law by Congress. These override the guidelines if they're higher than what the guidelines recommend. Trafficking 500 grams or more of methamphetamine carries a 10-year mandatory minimum. A defendant sentenced under the Armed Career Criminal Act faces a 15-year mandatory minimum. When a mandatory minimum applies, the judge has no choice but to impose at least that much time in prison. The safety valve is one way around it in drug cases. The other way is cooperation, where you provide substantial assistance in prosecuting other people. There are 2 vehicles. A 5K1 motion is filed by the prosecutor before sentencing, and a Rule 35B motion comes after sentencing, usually within a year when the cooperation happens or it becomes useful later on. The same idea, though, different timing. Here's the critical piece a lot of people, and frankly, a lot of lawyers get wrong. Filing a 5K1 or Rule 35 motion does not automatically let the judge go below the mandatory minimum. A standard motion only authorizes a departure below the guideline range. To unlock the mandatory minimum, the motion must specifically reference 18 U.S.C. 3553E, without that statutory language, the judge can reduce your guideline calculation, but the mandatory minimum is still the floor. This is why fighting for the lowest possible guideline calculation matters so much in a cooperation case. The government's motion typically recommends a reduction measured in levels off of the total offense level calculated by probation and adopted by the judge. If that starting number is inflated by a few levels you should have fought, you're cooperating off of a higher baseline, and every level you lost at calculation is a level you can't get back through cooperation. The decision to file and what language to put in it rests entirely with the prosecutors, not the judge. Even though the guidelines are advisory, judges follow a specific process. A departure is when the judge moves outside the guideline range based on policy statements in the guidelines themselves, things like extraordinary family circumstances or diminished mental capacity. A variance is when the judge exercises broader discretion based on the 3553A factors. These are factors listed in federal law that judges must consider: the nature of the offense, your history and characteristics, the need for the sentence to reflect the seriousness of the crime and provide a deterrence, the need to protect the public, the need to avoid unwarranted sentencing disparities, and the need to provide restitution. An effective sentencing memorandum shows the judge how these factors support a lower sentence. Here's how the guideline calculation actually happens in your case. After you plead guilty or are convicted at trial, your case is assigned to a United States probation officer who prepares the pre-sentence report, or PSR. The PSR is the single most important document in your federal sentencing. It contains the proposed guideline calculation, and that's what the judge starts with at sentencing. First is the pre-sentence interview. You and your attorney meet with a probation officer. They'll ask about your background, family, education, employment, mental health, substance abuse, and the facts of the offense. What you say here matters. Your attorney should be with you, should help you to be prepared. The probation officer then builds the report, pulling from the indictment, the plea agreement, the factual resume, law enforcement reports, criminal history records, and input from the prosecutor. Based on all of that, they calculate your offense level, criminal history category, and recommended guideline range. When the initial PSR is filed, you have 14 days to file written objections. This is a critical deadline. Any enhancement we think is wrong, any reduction you're entitled to, any factual error, any criminal history point that shouldn't count, all of it has to be identified and objected to in writing within that 14-day window. The probation officer's calculation is a recommendation. It is not final. The final calculation is made by the judge at sentencing. The judge rules on every unresolved objection, decides enhancements and reductions, and announces the final offense level, criminal history category, and guideline range on the record. Every level you knock off before sentencing is a level the judge never has to consider. Your sentencing hearing is one of the most important days in your federal case. The judge confirms you've reviewed the pre-sentence report, takes up any unresolved objections, and rules on each one. Once the guideline range is locked in, the judge moves to sentencing. The prosecutor argues for a sentence at or near the top of the guideline range. Your attorney argues for a lower sentence based on mitigating factors and the 3553A factors. Then you get to address the judge directly. This is called the allocution. Be sincere, take responsibility, don't make excuses. After hearing from everyone, the judge announces the sentence and either sets a date for you to report or remands you into custody immediately. If you're facing federal charges in Texas, the Northern District, which includes Dallas, and the Eastern District, which covers Tyler, Sherman, Beaumont, and other East Texas cities, have different sentencing cultures. Northern District judges vary, with some rarely sentencing outside the guidelines and others more open to arguments for lower sentences. The Eastern District tends to be more conservative overall. Working with an attorney who knows the specific judges and prosecutors in your district can make a real difference. Federal sentencing guidelines are extraordinarily complex. Small changes in your offense level, 1 or 2 levels, can mean years of difference in prison time. And remember, the federal system abolished parole in 1987. You serve nearly all of your sentence with only a maximum 15% reduction for good time. Identifying every possible reduction, challenging inappropriate enhancements, preparing a thorough sentencing memorandum with character letters and evidence of rehabilitation, knowing when to challenge things like the sophisticated means enhancement or the leadership role enhancement, all of this requires detailed knowledge of how the guidelines work in practice. The time to start working on your sentencing is as soon as possible, not just in the weeks before the hearing. Early intervention can affect how prosecutors charge your case and what facts get into the plea agreement. If you're facing federal charges in Dallas or anywhere in Texas or the United States, you need an attorney who understands these guidelines inside and out, who knows the judges in your district, and who can fight for the lowest possible sentence. I'm Michael Lowe. My office is in Dallas. I've been representing clients in federal criminal cases for over 25 years. If you need help understanding your guideline calculation, identifying available reductions, or preparing for your sentencing hearing, call my office at 214-526-1900.